Thank you, Mr Deputy Speaker. I'm pleased to rise to speak on the Copyright Amendment Online Infringement Bill 2015. This is an important bill which will provide an effective mechanism for copyright owners to disrupt the supply of infringing copyright content to Australian consumers. I'd like to emphasise 3 points in my remarks this evening. Firstly, there is a growing issue with copyright infringement in digital media. Secondly, there is a need to take action to address this problem. And thirdly, I want to speak about the measures in the bill which are directed to addressing the problem. Let me start firstly with the growing problem of copyright infringement. The copyright framework has existed for centuries, and the policy rationale is to incent creators to engage in the intellectual and creative effort to produce works, and the incentive arises because they can capture remuneration for their work. Typically and traditionally, the copyright framework has worked on the basis that a work, be it a literary work or an artistic work, a musical work, is created and then is disseminated on a per-unit basis. So it might be a number of records which is sold, a number of books which is sold, or a number of movie tickets which is sold. That is to say, there's typically, or there has at least historically, been a physical production process which is difficult to replicate. It's not easy to replicate the printing of a book if you're not the copyright owner. Of course, it can be done, but it's not the easiest thing in the world to do. The policy framework for copyright has always involved the striking of a balance between, on the one hand, the rights of creators and in turn owners of copyrighted works, and on the other hand, users and disseminators of those works. And striking that balance is never a simple or straightforward exercise. There's a range of considerations to weigh up. What we've seen, however, over the last 20 to 25 years is a new factor which has made the policy issues in this space even more complex, and that factor is the rise of digital technology as the means by which artistic, literary, creative works are disseminated. Today, if we think about the way that most people in Australia and in other advanced nations, indeed most nations, access music or access movies or television or books, almost invariably it's over a digital pathway. There are a whole raft of very telling statistics that could be quoted in substantiation of that proposition. Let me cite just a few from a compilation prepared by Teresa Spurty, who's an expert in digital marketing, and she's drawn together some interesting statistics from a range of reputable sources. For example, the Census e-business report, September 2014, which noted that 56% of Australians now own a tablet device, 77% now own a smartphone. The Deloitte Media Consumer Survey, which noted that the internet as a preferred source of entertainment continues to grow at roughly a 10% rate per year, and indeed in 2014 the percentage of people ranking watching television as their preferred source of entertainment amongst all Australian consumers surveyed was 64%. The percentage ranking using the internet for social or personal interests was 63%, and it was expected that the crossover between those two would occur this year. That's to say, use of the internet would become the most preferred source of entertainment. So digital mediums for the dissemination of material continue to become ever more important. Another interesting statistic, some 32% of Australians, according to the Deloitte Media Consumer Survey, purchase e-books. And of those who do purchase e-books, some 2/3 of them are reading more digital books than printed books. So there's ample evidence to support the proposition that content is being generated and disseminated using digital technology. And from both the point of view of producers and consumers, that's much more efficient and rapid than the traditional technologies. But one of the consequences of the use of digital technology is that it is much easier to copy a work than it hitherto was. And indeed, thanks to digital technology, the copy can be indistinguishable in quality from the original work. And the policy risk that presents, therefore, is that we end up in a world where it becomes very difficult to protect your copyright in a work. That tends to undermine the incentives of creators and also those in the business of disseminating content. And we know that we do have an issue in Australia with online copyright infringement. Indeed, Australia is a jurisdiction which has a relatively high rate of online copyright infringement or illegal downloading. According to some recent research, some 21% of all Australians over the age of 18 have engaged in illegal downloading. A statistic which is not one that should fill us with pride is that 11.6% of all illegal downloads of Game of Thrones happened in Australia. That's a percentage vastly in excess of our percentage of the global population. According to 2014 research prepared by the IP Awareness Foundation, online film and television piracy is increasing. 29% of Australian adults admitted to being active pirates. And the same research found that 1 in 4 teenagers engage in the downloading or streaming of infringing film or television content. So we do have a growing problem with copyright infringement when it comes to digital media, and I want to turn now to why it is important that we do what we can to address this issue. There are good policy reasons why seeking to address the issue of online copyright infringement is something that government should aim to do. To start with, it's clearly important that we are seen as a jurisdiction, a market, which respects and enforces copyright. That is critical to having and maintaining a vigorous set of creative industries in Australia in fields as diverse as film, television, music, literature and so on. According to a 2012 report by PricewaterhouseCoopers, Australia's industries that are across the range of industries that are subject to copyright protection, those industries employ some 900,000 people and generate economic value exceeding $90 billion, including $7 billion in exports. But of course, as I've been arguing, digitisation has tended to mean that these industries are particularly susceptible to harm from online copyright infringement. Of course, the second factor is that potentially online copyright infringement can be harmful to consumers. And a third issue that we need to take account of as we identify reasons why it's important to look at seeing if we can fix this issue is that there are deficiencies in the current law of copyright, meaning that it is not a fit-for-purpose tool in some ways in allowing rights holders to efficiently enforce their rights in this modern digital world. For one thing, there are a number of foreign-based websites that disseminate large amounts of infringing content to Australian internet users, and presently they're able to operate in practical terms without disruption, and their operators can secure a profit from facilitating the streaming and downloading by end users of infringing copies of audiovisual material, and of course the legitimate owners of that material don't share in the returns which are generated. It's, in fact, if we are clear about what is occurring here, unlawfully accessing and then profiting from the intellectual and artistic endeavour of others is a form of theft. Today, however, rights holders face a number of practical barriers when it comes to seeking to enforce their rights against the operators of these sites and these services. The most practical barrier of all, of course, is that the website that's facilitating this type of infringement, that's engaging, or the operators of which are engaging in this form of intellectual property theft, are typically located in its jurisdiction where it's very difficult, if not completely impractical, to take legal proceedings. So we have a specific problem in the current regulatory and legal framework which is available to the owners of copyright to enforce their rights, that it can be very hard to take enforcement action against entities which are operating outside Australia. You need to seek an injunction from a court, which requires lengthy and costly civil proceedings. And because infringement is occurring on quite a large scale, it's often not viable for rights holders to enforce their rights against individual users. Now, it's important to acknowledge there's a range of factors at play here, and it's been argued by a number of people in this debate that one factor has been that global rights holders tend to bring content to Australia later than it's made available in other markets and at higher prices. On that front, it is important to acknowledge that rights holders have changed some of their practices in recent years, and there's a number of constructive developments that we've seen in the last year or so. We saw Foxtel, for example, lowering its prices late last year, and we've seen new streaming services, Stan, Presto and Netflix, operating in Australia, providing greater access to consumers for legitimate content at reasonable prices. Let me turn thirdly then to the key mechanisms in this bill, which are designed to facilitate copyright owners taking action to disrupt the supply of infringing copyright content to Australian consumers. Specifically, the bill will enable copyright owners to apply to the federal court for an order requiring a carriage service provider, so typically that's going to be an internet service provider, one of the companies through which most Australians obtain their internet connectivity. So an order requiring an internet service provider to block access to what the bill calls online locations, where those locations infringe or facilitate the infringement of copyright, and that infringement is in fact the primary purpose of those online locations. Now, I think for present purposes we can understand online location as primarily meaning a website, but nevertheless that language has been used to take account of the rate at which technology changes and, of course, the mode of operation of some technologies where bits of content are spread very widely amongst multiple locations. Now, provisions of the kind contained in the bill have been used in other jurisdictions, including the UK, Ireland and Singapore, and in these jurisdictions an injunction is often ordered without any opposition from the internet service provider concerned. The provisions in the bill have been drafted carefully, Mr Deputy Speaker, to ensure that the new injunction power will not affect legitimate websites and services that legally provide access to copyright material. Importantly, the provision will apply on a no-fault basis against the carriage service provider, that's to say the internet service provider. This recognises that it's not necessarily the case that carriage service providers are responsible for the infringing online locations. They are, however, best placed in a practical sense to facilitate Australian internet users being prevented from accessing those locations. So there's a clear distinction being drawn between whether internet service providers are responsible for the infringement, that is not being asserted, that's not the policy basis underlying this bill, but whether, on the other hand, internet service providers are the party best placed to facilitate the legitimate rights of copyright owners being protected against those who are engaging in infringing behaviour. Importantly, the legislation has been drafted with a view to ensuring that the power in it is only as broad as it needs to be to achieve its objectives and no broader. There has been extensive consultation conducted on these measures, including a discussion paper released last year by the Attorney-General and the Minister for Communications, and a number of submissions, quite a number of submissions were made in response to that discussion paper, and there are certainly measures in this bill which respond to comments made in those submissions. So, Mr Deputy Speaker, copyright protection is an essential mechanism for ensuring the viability and success of creative industries by providing an incentive for and a reward to creators. That's the underlying policy rationale why the government is taking action here in this legislation with a view to reducing the rate of online copyright infringement in Australia. The government does want to acknowledge the collaboration and cooperation of a range of parties, including internet service providers as well as rights holders, in developing this framework, and the government looks forward to the ongoing cooperation of these stakeholders as we move to implement this framework.
I thank the Parliamentary Secretary for